We will hear argument first this morning in Case 24-556, Fernandez versus United States. Mr. Groenstein.
Mr. Chief Justice, and may it please the Court, when Congress established the extraordinary and compelling reason standard for sentence reductions under Section 3582, it chose words that set a high bar for when courts may grant such motions. It also chose words that do not prescribe what types of reasons will qualify. Instead, it delegated that task to the Sentencing Commission and required that district courts comply with the Commission's guidance when exercising their discretion under the statute. This case presents the question whether Congress has implicitly prohibited district courts and the Sentencing Commission from considering any reasons that may also be alleged as grounds for habeas relief. It has not. Under the plain meaning of the statute, if a court finds an error that significantly increased the length of the defendant's sentence, that fact can contribute to a finding of extraordinary and compelling reasons to reduce the sentence. And even when a court finds no error, it may nonetheless decide that the circumstances surrounding the defendant's sentence were so unusual and unfair as to be extraordinary and compelling. That's what happened here. The government's position is extreme. It contends that no argument related to a defendant's judgment may even be considered in the extraordinary and compelling calculus. It posits that only personal circumstances like age and illness are relevant. Our position is modest. We recognize that personal circumstances are common reasons that courts find to be extraordinary and compelling. But we reject the government's view that courts can never consider an error or unfairness in a defendant's sentence in that analysis. Allowing courts to grant a sentence reduction in rare cases based in part on circumstances that could have been addressed on habeas will not frustrate the habeas statute's procedural limitations. There is no basis to adopt the government's non-literal reading of 3582. I welcome the Court's questions.
Do you think the term compassionate release suggests the circumstances that you have in this case?
Your Honor, the term compassionate release is a term that has been used colloquially and was used at one point in a Department of Justice regulation. We certainly concede that that term does seem to relate to personal circumstances, but it doesn't necessarily foreclose the possibility that courts would consider other issues related to the fairness of the defendant's sentence.
During the years that the Bureau of Prisons actually initiated this process, were there any circumstances in which a trial error would be the basis of the motion?
Certainly, there were very few cases, period, when the BOP was involved.
But even in the few cases, were there any of this nature?
There were not, Your Honor.
What was the nature of those?
Those were generally where a prisoner was terminally ill or old. And
in other words, personal circumstances.
They were certainly personal circumstances. But we also saw, as our amicus fam on page 15 of their brief, they cite the Diaco case, which relates to the predecessor, 4205G, where there were cases related. There was one case relating to sentencing disparities, and that was one of the only two cases that are published about the use of 4205.
So there were two cases by BOP where they basically reference as part of the circumstances a change in law, correct? Banks, U.S. versus Banks, 428 F sub 1088, 1977. And in that case, the court considered rehabilitation, which is now prohibited by the new policy statement as being a sole ground, correct?
That's correct. In the case that Your Honor referred to is
But nevertheless, back then, BOP relied on rehabilitation, correct?
Rehabilitation, absolutely, yes.
And the Diaco case, I think you're minimizing it, that also was a New Jersey case where BOP made a motion to the court for compassionate release, and one of the factors was a change of sentencing, correct?
Absolutely, Your Honor.
So the two published opinions were both BOP and weren't limited to just personal circumstances.
That's certainly correct. Absolutely.
Counsel, you say the situations in which these would arise will be rare and unusual. Why in the world would that be the case? You've got somebody sitting in jail and they got 20 more years to look at, and you go in and say, gosh, I think there's like a 1% chance, you might be able to get out. The prisoner is going to say, oh, okay, it's only 1%. Let's forget about it. Every lawyer would bring these claims. And some judges are going to grant them and some are not going to grant them. And I'm not sure this factor is not something that Congress took into account. And it does seem that this is – well, why would this remain rare?
Certainly, Your Honor. And the reason it would be rare is precisely because of the habeas statute, that the defendant did have an opportunity potentially to raise these issues on habeas. Maybe he procedurally defaulted. He will then have to show why he procedurally defaulted. What were the circumstances surrounding that? Because merely procedurally defaulting on a potentially meritorious claim normally would not be found to be compelling.
Did the meaning of extraordinary and compelling reasons change in 2018 when Congress enacted the First Step Act?
That's not our position. Our position is that it has meant the same thing, and that would be the dictionary definitions of extraordinary and compelling, since 1984.
Well, until 2018, only the director of the Bureau of Prisons could invoke the statute, right?
That's correct, Your Honor.
Is it plausible that Congress intended for the director of the Bureau of Prisons to make motions for sentencing reduction based on an assessment of the strength of the evidence or any factor that has to do with the trial proceedings or the sentence that was imposed?
I do believe so, that it was at least possible, Your Honor, as referring back to the cases that Justice Sotomayor discussed.
Yeah, they're two isolated cases, but doesn't that seem to be far outside of the area of the director of the Bureau of Prisons' expertise?
Well, there could be
and issues. Responsibility.
That's certainly true, Your Honor, but I would suggest that the other agency that is involved in 3582 is the Sentencing Commission, and there was a delegation to the Sentencing Commission whose expertise, of course, goes far beyond the Bureau of Prisons to set up guidelines. The Congress did not delegate that task to the BOP.
And why would our consideration be limited necessarily to what was in the purview of the BOP? I understand that there was an amendment that allowed the statute or allowed these motions to be brought by a defendant and essentially bypassed the BOP. So I'm wondering if that doesn't indicate Congress's intent to allow for the consideration of factors that the BOP either wasn't able to or wasn't considering.
Well, certainly, yes. Justice Jackson, we do agree that when Congress amended the statute, the reason it did so, and it was quite explicit about this, was to allow more circumstances to be raised. It's our position. It's not because the BOP was not able by law to do so, but that the BOP was not bringing enough of these sorts of motions.
Well, counsel, you can't have it both ways. Either extraordinary and compelling reasons remained the same after the enactment of the First Step Act, which is what I understood you to tell me, or it changed in 2018, which is what you seem to have suggested in response to Justice Jackson. So which is it?
No, I'm not saying that the meaning of the words changed. I'm saying that what Congress intended in the First Step Act was to allow these sorts of motions to be made more broadly.
And in any event, I thought your argument was that Congress never gave content to extraordinary and compelling circumstances in the first instance.
That's absolutely.
In fact, ceded that authority to the Sentencing Commission.
Absolutely. And Congress used words that were intentionally broad to allow the Sentencing Commission to give guidance on circumstances that it might not have anticipated when it passed the First Step Act.
But the Sentencing Commission has not authorized this kind of activity, has it?
At this point, certainly for our case, the Sentencing Commission hadn't spoken. The current policy that was passed
has spoken or
has not, for purposes of our case.
Right, and in your opening, you therefore said the question is whether they've implicitly prohibited. Isn't the question rather whether they've authorized this kind of motion?
Yes, in our view, by using words that are as open-ended as extraordinary and compelling, and then by explicitly delegating to the Sentencing Commission the authority to give guidance, that is the authorization. Congress did two things here. One, it used very broad language, and second, it gave an explicit delegation to the Sentencing Commission.
Right,
Counsel,
but the Commission – I'm sorry.
No, finish.
But the Commission hasn't in turn said that this kind of legal error is a basis for this kind of motion, correct?
At this point, the Commission has not spoken to that. The Commission
shouldn't that be – or how relevant should that be in how we think about this? In other words, the Commission could – it's subject to legal challenge, but it could identify this kind of circumstance as the basis for such a motion, but it has not done so, even though it has been authorized, as you say, by Congress to elaborate on what the authorization means.
Yes, Your Honor. From 2018 until 2023, the Commission had provided no guidance that applied to defendant-initiated motions. So at that point, courts were simply acting under the meaning of the statute. So, yes, we certainly expect and we would hope that the Commission could provide further guidance on this issue, but it has not yet taken that opportunity.
Counsel, can I ask you a question about whether you have to go to 2255 first or whether you can go straight to the compassionate release statute? You answered when the Chief was asking you questions. In that interchange, you suggested that the prisoner would have to go to 2255 first because otherwise it wouldn't be a compelling circumstance for release. So are you reading kind of an exhaustion requirement into compelling so that someone in your client's position would have to try to get relief through 2255 first before invoking this other procedure, or no?
No, Your Honor, that's not our position. Our position is that as part of the extraordinary and compelling analysis, courts would consider whether a defendant sat on his rights or whether he's taken all opportunities to enforce his rights. Even if a defendant did not go through 2255, he would still have the option to argue under 3582 that his situation is extraordinary and compelling, but his position would be weakened by the fact that he did not take the opportunity to enforce his rights.
Why would you ever bother with 2255? Seems like it would be a lot easier to just go the other route, as long as you have some other circumstances to invoke.
Well, the first reason would be that 3582 sets a very high bar for defendants. It has to be extraordinary and compelling. Also, the relief that a defendant can obtain under 3582 is limited. He can only reduce the sentence, whereas the relief under 2255 is much broader. He can attack his conviction. Also, there will be plenty of errors where a court will not feel comfortable simply releasing somebody, but rather would want to correct the error by remanding by having a new trial.
But a First Step Act error, I mean, you've made the position, and it's true, Congress changed it because those sentences were extreme, right? They were extremely long. And it seems to me that if indeed that's extraordinary and compelling, the disparity between similarly situated defendants who get the benefit of the act and who don't, I mean, why wouldn't that be extraordinary and compelling on its own terms? And plus, there are downsides, too, to attacking the validity of your conviction, because then you could be subject to retrial.
That's right, Your Honor. And it certainly can be extraordinary and compelling. But to date, courts have interpreted the phrase narrowly. There have only been, by our count, 12 cases since 2018 when the First Step was enacted where a court, based on an argument that could have been raised on 2255, in part granted a sentence reduction. So courts have been using this very infrequently to grant relief.
But 2255 has some harsh limitations. There's a short statute of limitations. There is preclusion of second and successive petitions for the most part. Can't you imagine that defendants who face those limitations and, they filed their 2255 motion 3 days late or something like that, that this would then be used essentially as an end run around those prohibitions?
Your Honor, I don't think it would be an end run precisely because a 3582, even if you do claim an error, will not necessarily be granted. It will be difficult for that. And I agree with Your Honor that there are harsh limitations associated with 2255, and Congress has stated that those limitations are appropriate, but it doesn't mean that in every case, as applied to every defendant, that those limitations are fair. And under certain circumstances, if a defendant misses a limitation by 3 days, he may not be able to challenge his conviction, but he should at least be able to argue this unfairness, the error and the unfairness of him not having been able to bring it under 2255.
I suppose what I'm suggesting is that, Congress, for better or for worse, made a determination that those are the limitations that it wanted. And even to the extent that a judge thinks that they're unfair in all cases, in most cases, that I doubt that Congress meant for individual judges to override its own judgment.
Absolutely, Your Honor, and that's certainly a limitation that should be placed on 3582, that a judge cannot simply second-guess a decision made by Congress. But even where Congress creates a generally applicable law, such as a mandatory minimum, it doesn't mean that Congress even believed that in every case that would be fair to the defendant. And all we're asking for is that a judge can consider that the way the law has been applied to this defendant has been unfair or even potentially erroneous.
And I thought in response as well to Justice Kagan's point is the thought that the limitations that exist in the habeas context are relative to the actual aim of habeas and goal of habeas, which is vacatur of the sentence. It's also not discretionary. Where the defendant has satisfied the criteria of demonstrating that his sentence is unlawful, the court has to, according to the statute, give him habeas. And so, yes, there are strict limitations, but there's also this particular goal. It seems to me that compassionate release is a totally different thing. And so to the extent that compassionate release is about the court's consideration of a sentence reduction, one might think that the same limitations aren't intended to apply, that it's not actually an end run in any meaningful sense. These are just two different regimes, and it doesn't seem to necessarily follow that the considerations in one are mutually exclusive such that they can't arise in the other.
That's absolutely correct, Justice Jackson, and it's worth remembering that Section 3582 is as much an act of Congress as Section 2255 and should be given respect.
Is there anything in the statute or the legislative history to suggest that Congress wanted the 3582 sentence reduction dynamic to be limited in some way by what could have been raised in habeas or what is happening in the habeas scheme? Is there anything that links those two in the text or even in the legislative history?
Absolutely not, Your Honor. And, in fact, the Court has given guidance about how when there is a potential tension between two statutes, how that tension should be resolved, and that's the Prizer line of cases. And it's not simply that one statute can be seen in some circumstances to evade the other. What happened in Prizer in that line of cases was that 1983 was seen as a potential end run around every single constitutional 2255 motion. And that's why the Court found that a literal reading of 1983 would swamp the habeas statute. It would wholly frustrate Congress's goals. Here, allowing defendants to bring motions under 3582C1A in the rare circumstances that they could get relief, having a sentence reduction under those circumstances would certainly not frustrate the procedural limitations under habeas. And for reasons I said earlier, courts should actually take into account those procedural limitations.
And in fact, it would enable the kind of quote-unquote safety valve that Congress expressly in its reports, et cetera, in describing compassionate release. That's, I think, the design of it.
That's absolutely correct, Your Honor, and that's precisely how the two statutes sit one next to the other and not in conflict. Habeas applies generally to claims of error relating to a conviction or sentence. 3582 is the safety valve that can be applied to reduce a sentence should all of the other avenues of relief fail.
The question is safety valve for what? I mean, not every safety valve is a safety valve for everything. And I would not have thought that it's a safety valve in order to relitigate trial errors in the way that a 2255 motion is. That's the entire point of a 2255 motion. So, I guess I don't see any evidence that Congress meant for this to be a kind of do-over statute.
Well, Your Honor, perhaps the best evidence of it is the words that Congress used. They said extraordinary and compelling. Those are words that don't have a specific meaning, and it's given to the court to decide what is an extraordinary and compelling circumstance. So there are cases, we cited the Trenkler case, where someone had been sitting in jail for years. He was sentenced to a life sentence, even though the statute under which he was convicted, which had been amended just slightly after his verdict, and that's why no one picked up on it, said that he could not be not be sentenced to life. So in that situation, if he could have raised it under 2255, he should have. And maybe that detracts slightly from a finding of extraordinary and compelling. But when he's sitting in jail serving a life sentence that is unlawful, that's all we're saying is that that's something that courts should be able to consider as one of the factors, just as much as age and illness.
Well, suppose that a defendant, a prisoner, claims that there was a fatal error at trial, but doesn't bring a 22 after the direct appeal does not bring a 2255 for 3 years, therefore misses the statute of limitations. What would be extraordinary about that situation and would allow the prisoner then to try to get a lot of the relief that could have been obtained, maybe all of the relief that could have been obtained under 2255 by filing a 3582 motion?
Well, Your Honor, certainly there can be some things that are extraordinary and compelling about those circumstances. One, we would have to understand what is the prejudice that fatal error had on the verdict. Did it change it from an acquittal to a guilty verdict? Then why did the defendant, if this was such a glaring error, why did the defendant not bring a 2255? Maybe he had a mental breakdown and couldn't speak to his lawyers during that time. We don't know the circumstances. All we're saying is that all of the circumstances should be considered as part of the extraordinary and compelling analysis, the same way that personal circumstances.
I understand that. To go back to your answer to the Chief Justice's question, suppose you're advising a whole string of prisoners who have been convicted, they've lost on direct appeal, and for one reason or another, they all have claims of trial error or some other flaw in their conviction, but they're all barred from proceeding under 2255 because of the statute of limitations or some other factor. And you look at their claims and you think this is not a ridiculous claim. Would there be any circumstances in which you would not file a motion for sentence reduction?
Well, Your Honor, I think the same could be asked of anyone who has any medical illness or is approaching older age. Is there any reason they wouldn't? And this is precisely what the Sentencing Commission is authorized to do, is to put in guardrails. But to Your Honor's question, I think the close calls of when there's, potential error, I'm not sure that that's the sort of unfairness that courts would typically find extraordinary.
Well, I'm not even
and
talking exclusively about close calls. I'm talking about arguments that are not so frivolous as to damage your professional reputation if you brought them.
Well,
wouldn't you always do that?
Absolutely, Your Honor. And
so if this isn't going to be unusual,
I think
it's going to be standard.
I think what would be unusual is that courts would find the compelling circumstances that we're talking about. The First Circuit I cited in our reply brief, after Trenkler in 2022, there has not been a single case that we found where a court has granted a compassionate release motion in a situation where an argument that could have been raised on habeas was the basis for that motion. So we haven't seen that level of motions being filed. But we certainly anticipate, and Congress anticipated, that the Sentencing Commission can put the guardrails. The same way that the Sentencing Commission — I'm sorry.
Keep going. Sorry.
I'm just going to say the same way the Sentencing Commission dealt with the flood of these compassionate release motions during COVID.
But the Sentencing Commission, like Congress, has not authorized or envisioned or articulated anything close to this kind of legal error being the basis for this kind of relief. And that concerns me because, as Justice Kagan said, you don't see anything suggesting that Congress wanted a do-over kind of statute, but you don't see anything from the Commission either. Your case would be obviously quite a bit stronger if you had the Commission having identified this as they have with some other things.
Certainly, Your Honor, but I think that what we should read into the Commission's silence on this is that these will be cases that will be few and far between where a court would actually find the circumstances.
Well, how do we know that? I mean, first of all, as Justice Alito says, I think they'll be far more common that they're brought, so that'll be a whole new docket, one imagines, of these kinds of motions. But how do we know that individual district judges are going to, as your word, be modest or routinely deny these?
Well, Your Honor, certainly we haven't seen in the circuits that have allowed it. We haven't.
But if you win this case, one imagines that could, supercharge the efforts to use this.
That's correct.
In fact, you would want that, wouldn't you? Don't you want this to be used more often?
Well, I'm just representing my current client.
Yeah.
But
your legal position would.
Our legal position is that this should be something that should be in the mix. And certainly courts will take into account several things that I think would limit their exercise of discretion. First, they would take into the fact that there's the law of the case. If an issue had been raised, courts should not be revisiting it. Second, I think it's likely that these sorts of arguments will be made mostly in cases of mandatory minimum sentences, where the element of unfairness that arises from the error could not have been considered before. So we're seeing how the universe of cases where this sort of argument would be made is getting smaller and smaller. And rehabilitation is certainly an area where you would expect many motions to be brought in. There have been, but still the number of total compassionate release motions is modest, and if the Commission speaks more, will be even more modest.
Thank you, Counsel. Justice Thomas? Justice Alito?
Well, you just mentioned mandatory minimum sentences. There are a lot of district judges and other federal judges who don't like mandatory minimums. So if a prisoner has been sentenced to a mandatory minimum sentence, could a district judge say, if a motion under 3582 is made, you know what, that mandatory minimum is too much under the circumstances of this case, so I'm going to grant a sentence reduction?
Well, Your Honor, Section 3582 does allow sentencing under 3582 under the mandatory minimum for any extraordinary and compelling reason. But certainly it's our position that a court could not just say, I don't like mandatory minimums and therefore I won't apply them. It has to be something about the unfairness of that mandatory minimum in a particular case.
Would you agree that one of the principal goals or a major goal of the Sentencing Reform Act was fidelity? The Sentencing Reform Act got rid of parole. It didn't like the situation where someone would be sentenced to 30 years in prison. This was standard at the time. Maximum a life sentence was considered to be 30 years, but then after 10 years, the person would be paroled. It got rid of all that. Would you agree that that was a major goal of a major objective of the Sentencing Reform Act?
Absolutely, Your Honor, but it was also a goal in 3582 to have a safety valve where judges could still exercise discretion at a later point in the process.
Thank you.
Justice Sotomayor?
Counsel, I'm assuming here that a basic part of your argument is that actual innocence claims are not cognizable under 2255 at all.
That's based on our understanding of what the Court has said to date.
We've never said they are.
That's correct, Your Honor.
And so whether 2255 would be implicated in some other claim is irrelevant to your claim. this is an issue that couldn't even be raised there, not because of a procedural bar or anything else, but it's just not cognizable.
That's correct, Your Honor, and that's one of the difficulties in this case is that
All
if
right,
the
now,
courts...
may I go back to a problem I have with your case, which is all of the facts that Judge Hellerstein relied upon were known to him at trial. He knew what your client's claim of innocence was. He knew all the evidentiary weaknesses that he wrote about in his current opinion. He knew that only one shot came from your client's gun, et cetera, et cetera. The only thing he did not know was the exact reduced sentence that the co-conspirators would receive because they were sentenced after your client. But he knew they were going to get a substantial reduction because they were cooperators. How do we call that new and compelling evidence? Compelling or extraordinary evidence. There's nothing new. I would have an easier time if I thought that actual innocence had been proven after the fact.
Yes, Your Honor. There was another fact that Judge Hellerstein did take into account that he had not focused on previously, which is that the getaway driver was sentenced to 2 years in prison. And that suggested to him that the government itself had concerns about the credibility and the reliability of the cooperator's testimony.
All right. Now, you said earlier, and I agree with you, both age and medical condition or any other reason doesn't ever stand alone, because there are old people who are not released from prison. There are sick people who are not released from prison. It's one among many circumstances. Your claim of, and I put it in quotes, actual innocence doesn't stand alone. But what does it stand with in this case? There certainly was no medical need. There's no age need. There's no extraordinary circumstance to this individual. So why isn't it only one factor?
What it stands with, Your Honor, is the fact that despite the judge's concern about innocence, that this defendant was sentenced to a life in prison.
That is what bothers me.
But, Your Honor,
that it's a judge's disquiet as opposed to an individual circumstance. Because no matter how you look at extraordinary and compelling, it focuses on the individual, not on the judge's disquiet. By the way, I was a district court judge, and I have a great deal of respect for the disquiet that sometimes judges feel. It happens to every district court judge. There's a case where you really struggle. But can we, in the facts of this case, denote that that is an extraordinary circumstance?
Well, what I would say, Your Honor, is that this is the sort of discretion that judges generally have in sentencing, and it's reviewed on appeal for abuse of discretion. The Court of Appeals didn't review it for abuse of discretion.
Well, I agree with you, and maybe that's what they should have done. But I am troubled by this. Thank you.
Justice Kagan?
I mean, just to continue in that vein, do you think that the district court here on the initial trial could have received the jury's verdict of guilt and said, I'm not going to overturn that verdict of guilt. I have no basis for doing that. But in the sentencing, I'm going to reduce the sentence because I feel disquiet with respect to that verdict. Could the district court have done that?
Well, certainly not in this case, Your Honor, because it was a mandatory life sentence. But as a general matter, while the court does have to take the verdict as given when conducting the guidelines analysis and the